we've engaged with democracy from all possible angles, and as you know, this conference is being co-convened by the Office of the Deputy Vice Chancellor, Engagement and Transformation, and then also the Dean of Humanities here at Nelson Mandela University. And in terms of how we've put it together, we really wanted to look at democracy from all possible angles. And of course, then authoritarianism came up as a theme quite consistently throughout the conference in various guises to various extents. We engaged critically with the question of inclusion, whether rural people finding themselves in South Africa under traditional councils, queer people, women, poor people, how can one engage with the question of inclusion, which is clearly one of the reasons why democracy is under so much pressure. The fact that you've got these dynamics of exclusion, socioeconomic exclusion, which is really about capitalism as a system and how it works, particularly the neoliberal form that we are currently still within, how it works, how it excludes people, how it, when it includes people, how it includes people in very exploitative and provisional ways, and so forth. And how this interaction between, on the one hand, the capitalist system and democracy actually puts democracy under pressure because of these dynamics of exclusion or provisional inclusion. And a lot of this also has to do, of course, with the nationalist imaginary, various forms of nationalism and how they include and exclude. We have touched here and there, we've referred to the question of populist nationalisms that are on the rise across the globe, as we know. And we will today for the question of nationalism in the session later this morning. So please tune in for that, because I think it's very important for us. If we want to understand the pressure that democracy is finding itself under, it's very important for us to understand the question of nationalism and how nationalism, the kinds of permutations that it is adopting. So these processes, as we know, are very much race and gendered, and we have actually worked through a number of perspectives and inputs on understanding race, understanding gendered processes in relation to democracy. We also particularly homed in on the institution of higher education to try and understand how race and at the intersection with gender is still playing itself out, and what are the possibilities for social justice also in relation to higher education. We know that there are very much contestations around sex, gender, sexuality. We looked at those from a number of angles. We also looked at institutions and laws and the challenge of holding political elites to account using both institutions and laws in different settings. So we heard a paper from looking at, for example, Uganda, where activists are operating under very difficult circumstances of authoritarianism, and it was interesting to make comparisons to a situation like that of South Africa, where we have quite a different set of laws, different institutions that work in different ways, but that there are also various challenges being experienced by activists. So this whole question of activism, the possibilities for activism, the various approaches that can be taken to try and extend and deepen, yet again, inclusion, this question of inclusion, these various groupings of people who are presently either marginalized or excluded, and how they can be brought in. And we also looked at the question of revisiting democracy through its vernacular expressions. And I think that was a fascinating paper from from the Centre for Social Change at the University of Johannesburg yesterday that can definitely be further explored. So looking at this question of the decolonization and the Africanization of democracy by bringing in top-down understandings, not top-down, bottom-up, of course, understandings of democracy, bringing that to the fore, and very, very important work being done there. Constitutionalism has been a thread throughout, and we will continue that in this morning's session. And yet again, this question of authoritarianism also in rural settings, which we will continue in this morning's session as well, understanding what is happening for people who find themselves in rural settings under traditional councils. And so that theme has been running throughout from Tuesday evening until now. We looked at different political styles. Our second keynote also underlined for us the fact that leadership matters. Leadership is important, and this is and he was looking particularly at the leadership of Mandela and holding that up as a particular model that goes quite against the kinds of leadership models that people frequently embrace. And talking about the question of a society in trauma, a society traumatized by colonialism and apartheid, and how publics can actually opt for leadership that is not in their best interest. So trying to understand that was also a very, very important engagement. So, but we are at the start of our final day, and as I say, it's been a very rich conference so far. Today we are looking forward to many different inputs also, particularly from our own university, the Nelson Mandela University here in Gqeberha in the Eastern Cape, South Africa. We also have colleagues joining us from the University of the Free State, the University of the Western Cape, the University of the Witwatersrand, Rhodes University, the Bari Global Research Network in Slovakia, and also the Doha Institute for Graduate Studies in Qatar. So we also have colleagues joining us in the roundtable on publishing, so people interested in understanding dynamics of academic publishing. And we know, of course, there's a very strong north-south global dynamic in terms of how academic publishing actually plays out. And so people interested in engaging on that, we've got a roundtable today with publishers, including people like publishers from publishers such as the colonial publishers. We also have the editor of the Socialism and Democracy Journal. So a very strong day lined up for us. We're looking this morning at constitutionalism, land and securitization in response to COVID-19. After that, we will go into parallel panels and we will be looking at nationalism and black conservatism and neoliberalism and the left. And then our roundtable, as I mentioned, and then we will be ending off with our closing plenary that will be looking at community engagement as it's been practiced for the past decade here at the Center for the Advancement of Non-Racialism and Democracy. So, let me, without further ado, launch us into our first panel. I'm very excited to have a wonderful group of people joining us here this morning. And as I said, we will be talking about constitutionalism, land and securitization in response to COVID-19. With us, we have this morning Professor Dani Brandt, who is at the University of the Free State, the Center for Human Rights, and he will be talking on courts, accountability and democracy under COVID-19. Then we have Professor Richard Levin and Dr. Ngubane joining us. Richard is from Nelson Mandela University and Ngubane is from the University of the Western Cape. And they'll be talking to us about deepening South African democracy in rural spaces, the political economy of labor tenant claims resolution. So I think that's going to be a very important conversation as well. And then joining us from Slovakia, we have Dr. Luza Surova joining us, talking on the situation requiring the adoption, the securitization and quarantine of the Roma settlement during the COVID-19 pandemic in Slovakia. And Dr. Shirovia is joining us from the Bari Global Research Network in Slovakia. So very, very welcome to all of our speakers this morning. We will, as you know, you have 15 minutes each, and we've got our counter running at the top there just to remind you of where you are in the process. So Corby and Ngubane and Richard Levin will be talking on deepening South African democracy in rural spaces, the political economy of labour tenant claims resolution.
Good morning, everyone. Thank you for putting up the presentation. I'll be presenting with Professor Levin. Our presentation is Deepening South African Democracy in Spaces, the Political Economy of Labour Tenant Claims Resolution. Thank you. Labour tenants on South African farmland were incorporated into state relations of power as subjects, perhaps similarly to the way that black people were subjected to state relations as subjects during the apartheid period in the former Bantustans. So under the democratic dispensation, more than 20,000 labour tenant households lodged land claims. And in 2020, after a long period of snail pace labour tenant claims resolution, a special master was appointed by the Land Claims Court to supervise, monitor, and oversee the resolution of labour tenant claims. So our presentation examines possibilities of deepening democracy and transformative constitutionalism. So the presentation explores prospects for successful, all-encompassing land reform. Slide.
Okay, now, thank you. Both in history and in law, the story of labor tenancy in South Africa is one of persistence and defiance, both by landowners and labor tenants, obviously for different reasons. And during the 18th and 19th centuries, labor tenants were permitted to engage in crop and livestock production on various amounts of land in exchange for virtually unpaid labor, a practice which has persisted well through the 20th century and indeed into the 21st century. Labor tenants often receive some form of remuneration in the history of labor tenancy and the development of capitalist agriculture. Next slide. A key moment, though, if we're looking at the more recent history, was the amendment.
I think we've got a connectivity issue there, unfortunately.
Yes. So labor tenants in history and in law, the 1936 Land Native Trust and Land Act was amended in 1956, requiring the registration of all labor tenant claims and establishment of labor control boards. And the NEL Committee of Inquiry into the labor tenant system recommended in 1961 that legislation be introduced to outlaw labor tenancy and replace it with agricultural labor. The resistance from white agriculture to the abolition of labor tenancy may be because mechanization did reduce demand for cheap labor, but led to capital substitution with reliance on casual labor. Next slide. Farmers in Natal and some part of the Transvaal were resistant to the abolition of labor tenancy, but it was finally abolished in 1979, and about 1.2 million people were forcibly removed by 1983, removed from white farms. Next slide, please. So we see that labor tenants have been treated as subjects and not citizens. During colonial and apartheid period, labor tenants operated within a legal framework beyond the farm, divorced from the everyday reality. it was not a uniform system regulated by national law. Instead, it was a decentralized despotism. This is why labor tenancy persisted after it was abolished nationally by the apartheid government. It also laid the platform for
Okay, I'm ready. So Ngobi can just usher me in.
Yes.
Maybe finish that slide that's up and then change, and I'll carry on from there.
I think it's a perfect moment, Richard. The labor tenants as subjects and not citizens were on this slide.
No, thanks for keeping the fire burning there, Ngobi, and apologies for the technology challenges here. But I think really the situation is that what was happening in law and what was happening in reality were very different. There wasn't really a uniform national system, and we had a form of what Mahmoud Mamdani has referred to as decentralized despotism going on in white farming areas. So even if legally labor tenancy was abolished, it persisted. And like I say, the presence of casual labor, despite the fact of mechanization, was critical in certain parts of the country, particularly the northern parts of KwaZulu-Natal and parts of the former Transvaal. And I think this laid the basis for labor tenants being subjects as opposed to citizens during the colonial, apartheid, and post-colonial periods up until the present. So I think the important thing is that historically, the material conditions of labor tenancy have been shaped by the specificity of the political as much as by political economy. Why did Black people keep in it? Well, their choices were limited, but they did want to produce commodities, and they actually were competing with white farmers, but they didn't have land. That's the quotation that heads Charles van Onselen's famous book on Kasmaine. So labor tenants, cash croppers, farm workers were really nomadic groups. And the distinctions are obviously there in theory, but in practice, the distinction is often very, very blurred. But the majority of Black people resident in white farming areas didn't want wages or rations, they wanted land. That was really what they were looking for. And they were producing commodities. But at the same time, there was no civil rights that they enjoyed. Farmers became agents of the local state. They disciplined Black people. And there was a real threat from the perspective of the colonial and apartheid periods of small Black producers competing with white farmers. And obviously, in terms of apartheid ideology, living with Black excellence was something that could not be tolerated. So the abolition of labor tenancy, their removal from land through eviction, through relocation, was a consequence of economic coercion from above, and it stifled their prosperity as producers, as sharecroppers, as labor tenants. And they were an economic threat through their long-term demand for extra land to expand their agricultural production. And they operated in a variety of value chains, and these included livestock predominantly, but also crop production, maize in particular. And that's why, if you look at Themba Ngubane-Toby's latest book, the main issue one of the main issues he focuses on is the theft of cattle. So dispossession of cattle very much accompanies dispossession of land in the colonial and apartheid histories of South Africa. So one of the key issues is, well, what was the level of organization in the countryside in South Africa? Obviously, it differed in the so-called reserve areas compared with in white farms. And there are moments in all the areas where there was organization. But I think the national liberation movement also suffered from a paucity of analytical rigor when it came to the agrarian and land questions. And there was an idea of linear progression from being peasants into being proletarians, but the reality on the ground was very different. And that's why practices like labor tenancy persisted with small commodity production by labor tenants. I think also then the challenge becomes post-apartheid. What I heard Christy referring to is the kind of neoliberal policy framework and the social pact through the government of national unity, which arose, and the failure of white farmers or agriculture, like all sectors of capital, to meet their obligations in terms of the social contract. But there were legislative measures taken, and the Land Reform Labour Tenants Act was an important intervention with all its limitations. It did open up the space for labour tenants who were defined as applicants whose parents or grandparents had access to grazing and cropping land and performed labour duties for a landowner on a seasonal basis, on a contractual basis. And the problem, though, was in executing the act. The department responsible for it moved very slowly. So we had a situation whereby various applicants grouped together in a class action case against the government, a case that lasted 7 years and ultimately culminated at the end of 2019 with the appointment of a special master, who happens to be myself. So I think this is really the background to the appointment of the special master and the attempts to really intensify implementation of the act. But I think basically the reality on white farms, whether we're talking about labour tenants or farm workers, and the actual divisions are quite thin, they're quite blurred between those social categories, is that the neoliberal policy framework conceals the violent, oppressive character of labour tenancy and the life of farm workers on white-owned farms. And there's violence all around, and white farmers do get murdered, that's true, which no one would obviously agree with. But it's not like farm violence is about white people being murdered. Farm violence is about as much as that as it is about black people being oppressed. We've already in our work picked up severe cases right into the present period of brutal attacks on labour tenants. But there is this discourse around power as though it's a one-way process. And we've seen white farmers, for example, issuing labour tenants with permission to occupy certificates, enacting extrajudicial relocations, despite the existence of Section 8 of the Labour Tenants Act, which requires judicial supervision over relocation of labour tenants within a single farm boundary. Ngubane, you can continue. Thank you. Okay, Ngubane seems to okay, so maybe I'll just have to continue there.
No, Richard, Ngubane just didn't switch on his mic, so I'm just asking.
Thank you.
There it is. Great, thanks.
Okay, great.
Thank you so much. What then about labour tenants and political economy? We see that the neoliberal policy discourse reflects the realism of liberal and neo-radical academics whose recommendations for land reform include conservation of white-owned land so as not to disrupt agricultural production. This minimalist approach to the resolution of the land and agrarian question undermines the residues of agricultural capacity and skill of labour tenants. This influences officials who facilitate settlements of claims on land which labour tenants currently reside and use, legitimizing historical land and wealth dispossession. Over the past 70 years to the present, labour tenant households have faced systematic land dispossession, denying them quality land for grazing and cropping, and further squeezing them onto marginal farmland. So, to argue that labour tenants must then be only allocated land on which they currently reside is to assert that their marginalization must be formalized. Allocating black people to small pieces of land in South Africa was first suggested by Cecil John Rose and later bolstered through legislation. This triggered the process of constituting rural people as subjects, not citizens. The migrant labor system and the super exploitation of black people on the mines and in agriculture. Allocating black people to marginal land in South Africa today is part of this historical genealogy and is an apology to large-scale capital. It is non-confrontational, but excuses capital from meeting its obligations during the transition to a non-racial democracy. In the context of post-apartheid South Africa, the collusion of landowners, state officials, and lawyers raises the spectra of post-apartheid betrayal. The class character of this collusion is a bourgeois one. It frustrates the aspirations of the oppressed as well as their rights. It also raises allegations of corruption. In these circumstances, the state-funded lawyer and the state official may purchase assets with a bribe. The landowner holds on to the land, whilst the promise of the Constitution remains empty for the labor tenant. Labor tenants' struggles and pathways to freedom. Labor tenancy remains a battleground of daily struggles, even today, where we see, for example, in some parts of KwaZulu-Natal where there are timber plantations, timber production has seen ongoing relocations of labor tenant households to marginal spaces of timber plantations. Secure land tenure on arable land must be allocated for expanded job creation. So, for example, there are suggestions to how to execute land reform on these timber plantations, for example, through giving labor tenant households contracts, small-scale contracts in the harvesting of timber. But other land use, such as small-scale livestock production, cattle, goats, piggeries that are currently squeezed by timber plantations may be explored. Furthermore, alternative forms of production and land use should be explored, including possibilities of resuscitating original grasslands that disappeared over time owing to the encroachment of timber plantations. This brings us to large-scale commercial agriculture as the utopian agricultural production system, as if there are no other options that could be explored. The struggle for land, above all, is a struggle for justice. If South Africans agree to have a frank discussion about land disposition and land reform, that conversation must be guided by the principle of justice. Knowing the perpetrators need not mean the violation of individual rights and human dignity. Conditions of landlordism on private land must be transformed in order for democracy and citizenship by black residents to be realized. Despite the limitations of the land reform program, beneficiaries are resuscitating themselves through new forms of petty commodity production. Here we are talking about the recently redistributed land, the land that has been redistributed to former labor tenants. We are seeing petty commodity production, particularly thriving livestock enterprises in Free State, in KwaZulu-Natal, and in some parts of Mpumalanga. But this project of giving land to labor tenants is also about dealing with the trauma, the violence, the psychological torture that they had to endure. And this could be part of deepening our democracy. But then,
Ngubane, could you please wrap up? I gave you a few extra minutes because everything has been so technologically challenging this morning. But if you could please wrap up.
Okay, I'll just go to the conclusion. So the question is, as we conclude, is there a renewed optimism? Well, there are myths as well, and myths have great power. And successful land reform through the Labor Tenant Act is compounded by the creation and reproduction of these myths. And what are these myths? Number one, labor tenants aspire to small pieces of land and residential rights. Labor tenant households are mere farm dwellers and not producers of any agricultural commodities. Labor tenants do not aspire to farming, but to off-farm migration. And this is romanticized as if people migrate off farm for a good and prosperous life in urban areas. And the fourth, and perhaps the most devastating myth, is that black people cannot farm. Richard, the last slide.
Just switch on your mic, please, Richard.
Can the hope of the special master be fulfilled in practice? The myths that Ngubane referred to obviously need to be dispelled. There need to be adequate resources, of which there are not at present. But public administration values and principles must be realized. People's needs must be respected. Public administration must be developmental. And at the same time, it must be participatory. Officials act as though they're doing a favor by giving very poor settlements to labor tenants. They must really be much more empowering. But labor tenants themselves will need to find pathways towards organizing themselves in order to bring the necessary pressures for a combined societal approach to resolving these very complex problems. We thank you for the opportunity.
Thank you so much to Richard and Ngubane for that paper. It really draws one of our central themes right through from the very start of this conference. And I'm looking forward to our conversation about this. Please do post your questions in the Q&A and in the chat. Questions, comments, welcome. And yeah, let's start populating the Q&A chat. Yeah, looking forward to hearing from you as the audience. Now, over to Professor Dani Brandt. Sorry, Dani, for cutting you off. The mistake was completely on my side. So, Dani was talking on courts accountability and democracy under COVID-19.
Thank you, Christy. We are all under the cosh of technology, so never mind the mishaps. Can you hear me now? Okay, good. So to start off, thank you again to Christy, to everyone else who have been involved in arranging this conference. I must say, even though it is in this anemic form, it is wonderful to be part of a conference again. So thank you very much. Thank you also to some of the papers, the presenters of papers that I've been privileged to listen to over the last few days, and to my fellow presenters on the panel for appearing on this panel with me. So let me kick off. You have the title of my paper. In the first few months of the COVID-19 crisis, from March onwards last year, with other of the usual mechanisms of democratic accountability, such as regular parliamentary oversight absent, with the exercise of direct democracy through protest action prohibited, and with accountability through elections rendered irrelevant by the acuity and the immediacy of the crisis, people often turned to the courts to exact accountability from the state, to enact almost democracy. Perhaps the most dramatic example in this time of the people calling the state to account through the courts is the judgment of Judge Norman Davis of the North Gauteng High Court in the case of De Beer and others against the Minister of Cooperative Governance and Traditional Affairs, the De Beer case. In this case, Judge Davis declared the entire law of lockdown as it then stood under level 4 of lockdown. So the whole set of regulations issued in terms of Section 27.2 of the Disaster Management Act to give legal form to measures to combat the COVID-19 crisis, unconstitutional and invalid in one fell swoop. Unsurprisingly, that judgment was big news immediately as it was handed down. In the welter of comment that it elicited, the fact of the judgment was generally welcomed, but its quality was criticized. It's been described as woefully under-reasoned, muddled in its understanding and application of constitutional analysis, and with an order it does not support, that's also both overbroad in scope and vague in giving direction to the minister against which it was directed. So the consensus from the start was that due to these patent flaws in the judgment, it would not survive the appeal it was bound to be subjected to, so that it would end up as an important opportunity for accountability through the courts lost. And so it turned out. The case was appealed to the Supreme Court of Appeal, which in July of this year, in a judgment scathing in its criticism both of Judge Norman Davis and of Mr. Reino David de Beer, the guy who brought the case, not only overturned the entire judgment of the High Court, but for good measure also referred the case to the National Prosecuting Authority for it to investigate whether Mr. de Beer should be charged with the quaint offense of scandalizing the court. So in my paper, I ask whether, despite its obvious flaws and its spectacular, almost salacious in certain respects, failure, the de Beer case does not deserve a second look. Are we not required to assess the judgment on its own terms, that is, in the context within which it was decided, and in light of the demands of that time and place, a time and place of crisis? Should we not, in light of this context, apply to it a gaze other than the technically legal gaze? And if we do, might we not come to different conclusions about its quality as an instance of accountability, and so as an exercise in democracy? And finally, might the case not tell us then something about the relationship between courts and democracy, and notions that we might harbor about the nature and quality of that relationship? I start first by describing the case, hopefully in brief terms, both the judgment of the High Court and that of the Supreme Court of Appeal, and then I proceed to consider the case instead of from a technically legal perspective as an instance of the exercise of democracy. And I conclude by exploring what the case perhaps tells us of the relationship between courts and democracy, and the capacity of courts to host democracy in different ways, to act as a vessel for democracy, as they were required to do during this extraordinary time. So first, the case. So the de Beer case was brought in breathtakingly broad terms. It was, in essence, a challenge brought by Mr. de Beer to the whole law of the lockdown. He challenged the validity of the declaration of the national state of disaster and of the entire set of regulations that was in place at that time in terms of the Disaster Management Act, level 4 lockdown at the time. His challenge to the declaration of the national state of disaster was rejected by the High Court for sound reasons. I focus on his challenge to the regulations, which was upheld in the event by the High Court. And the whole set of regulations was challenged by Mr. de Beer on two grounds. In the first place, he argued that the regulations as a body were irrational, and more or less his argument, which was accepted by the court, was that there were inconsistencies in the regulations. He asked, for example, why people would be allowed to go to funerals once someone has died, 50 people, up to 50 people at a time allowed to go to a funeral, while they are not allowed to visit that person before he dies. And he pointed to various other inconsistencies in the regulations as basis for his argument that the regulations were irrational. So that was the first basis on which he challenged the regulations. Secondly, I think more importantly for my purposes, he challenged the regulations on the basis that they violate various constitutional rights. Didn't specify really. This is one of the reasons why the Supreme Court of Appeal eventually overturned the judgment. Didn't specify which constitutional rights, but one can assume constitutional rights such as the right to freedom of movement, the various religious and cultural related rights, and so forth. So the High Court granted his application, apart from the challenge to the declaration of the national state of disaster, and it held that the regulations were irrational in the sense that Mr. de Beer had raised that. And importantly, held that the regulations were unconstitutional, not because they violated any particular constitutional right, but because they were adopted and conceived in an unconstitutional manner. So in the affidavit deposed to by the Director General on behalf of the minister, the Cocteau minister. The minister admitted, or the Director General admitted, that in fashioning and in adopting the regulations, they failed at all to consider the extent to which those regulations, in an effort to protect everyone's life and health, would impact on other constitutional rights. And they failed at all to enter into a kind of a proportionality consideration to decide how they could best ameliorate that impact on other constitutional rights. So the minister admitted this, and Judge Davis seized on that fact to hold, therefore, that irrespective of whether the regulations in fact impact on specific constitutional rights, they were unconstitutional because they were adopted in this manner. They were adopted without that proportionality consideration being entered into by the minister. And on this basis, the High Court then declares the entire set of regulations, with one or two exceptions, for example, the prohibition on the sale of tobacco and so on. He declares the entire set of regulations unconstitutional and invalid. He suspends that order of invalidity for 14 days and then orders the minister within those 14 days to review, as he put it, the regulations, the whole set of regulations, to remedy whatever irrationality might be in them, and then also to enter into that proportionality exercise. Okay, the minister appeals this decision immediately. After some wrangling between the parties, eventually gets leave to appeal to the Supreme Court of Appeal, and the Supreme Court of Appeal, after hearing the case, overturns the judgment of Judge Davis in the High Court. And I'm going to spend brief time explaining what the judgment of the Supreme Court of Appeal entailed, and then conclude with some consideration of that. So at the center of the Supreme Court of Appeal's decision to uphold the appeal to overturn Judge Davis's judgment is a basic rule of civil procedure in our law, which is that our civil procedure is party-driven. In other words, the implication being that a court decides a case on the basis that it is brought to it before it by the parties. One of the implications of that rule is, for example, number one, that the parties must bring a cognizable case before the court, a case that is clear and that can be understood. But then secondly, an important implication is that the court may not fashion itself the case. It must stick to the case that the parties brought before it. And the Supreme Court of Appeal, virtually its entire judgment is based on its conclusion, number one, that Judge Davis decided the case on the basis of issues, that question of the proportionality consideration, on issues and on facts that were not raised by the parties. And that's the main basis for the Supreme Court of Appeal's holding that the judgment should be overturned, that the appeal should be upheld. The court also says that the primary basis upon which the regulations were invalidated by Judge Davis, being this idea that they were not properly considered and the impact on constitutional rights were not properly considered, so that was not clearly raised by Mr. De Beer specifically, and therefore could not form the grounds for the judgment. So the Supreme Court of Appeal doesn't enter at all into a consideration of whether or not on that basis the regulation should be set aside. It simply holds on that basis that the court overstepped its mark, so to speak, that the appeal should be upheld. Okay, now what can we say about the case also as it was decided in the Supreme Court of Appeal? First question for me is why do I look at this case in order to see something about democracy and the operation of democracy through courts and in courts? What was important for me about this case? There were, at last count, almost 400 COVID-related cases decided by our courts, or pending at the moment before our courts. almost 100 of those deal in similar terms to this case with the validity of regulations or with the validity of the exercise of regulations and so on. So why this particular case? So there are two reasons why I think this case is significant, despite all of its flaws and so on, is significant to use to consider the relationship between courts and democracy. The first is that it was a case brought by an ordinary person, so no political party or special interest group involved. It's an ordinary person. He turned out not to be so ordinary. He turned out to be quite idiosyncratic, but nonetheless. It was a case brought in order not to protect or advance his own interests. Not at all. His own interests don't figure at all in the case, but brought in the public interest. He says that in the judgment, in his application, Mr. De Beer, and he also litigates the case on that basis quite clearly. So not to advance his own interest. The second reason why I think this case is important is that the fact that the applications were in some sense not directed at the regulations themselves, but at the manner in which they were conceived and adopted. So Mr. De Beer's complaint is not really the specific regulations and the manner in which they impact on people's lives and so on. His complaint is really that the regulations were adopted in a manner that is undemocratic. So in some sense, he comes to court to vindicate democracy, not to vindicate rights, not to vindicate interests, but to vindicate democracy. So in that sense, De Beer's case, again, despite all of its flaws and so on, is really the case that to me most explicitly amounts to an application for the court to uphold an enriched and a non-liberal form of democracy, the kind of democracy that I think our Constitution envisages. Second reason why I think the case is significant is because of the emphatic, the almost virulent way in which the community of legal commentators and then the Supreme Court of Appeal rejected specifically that case. Brought in the manner that it was. It rejected the case almost as though it was cleansing itself of a virus, and the irony should be clear. So I think against that background, the case to me is a particularly good one through which to consider to what extent courts are open to, receptive of the exercise of enriched or constitutional notion of democracy. This very firm, emphatic rejection of the case because of the manner in which it was brought. Okay, I see my time is up. Christy, can I take 1 minute to conclude? Okay. Then to turn to what the case perhaps says to us about democracy and about the capacity of our courts to deal with democracy, to host the democracy in a sense. And I think there are three things, and I'll just touch on each of them, and then perhaps in the question time I can expand. The first is that clearly our courts are vehicles through which one can enact democracy. Many of the other cases that were brought to challenge COVID-19 regulations were successful in part or in whole. This case was not successful. And the reason why this case was not successful is because it was brought to advance a particular notion of democracy. And our court's rejection of that particular notion of democracy, one that focuses on the common good, one that is brought in general rather than specific terms, indicates the extent to which our courts, the rules that they apply, the rules of civil procedure that they apply, enable only a very anemic, very limited notion, liberal notion of democracy that focuses on the advancement of individual interests. That is what our courts are geared to vindicate in terms of democracy, not a broader constitutional form of democracy. Secondly, I think what is significant is the extent to which the Supreme Court of Appeal was unable to recognize what this case was about. It was unable to move outside of the framework of seeing litigation as a competition, a dispute between two parties in which they seek to vindicate their interest. Whereas this is precisely not what Mr. De Beer, despite his problems, was trying to do. He was trying to raise a point about democracy and to vindicate democracy in that sense. And then thirdly, I think what is interesting for me about the Supreme Court of Appeal's reaction is this, and this is perhaps a gratuitous point, but I'll conclude with that, the extent to which the court proved itself unable to deal with the messiness of democracy. If in the question time I have time, I will refer you to some of the things that Mr. De Beer had to say in correspondence with the court that angered the court to the extent that it ordered that the case be referred to the National Prosecuting Authority because he had scandalized the court and he should be charged with that offense. But this event in the judgment shows to me the extent to which the court is unable to deal with the messiness, the excess of democracy. Who is it? Robert Kennedy, who said that democracy is messy, it is hard, it is never easy. And the court was simply unable to deal with this person rather than institution or lawyer that appeared before it. And this person that appeared before it, warts and all, rambunctious, irascible, irritating. The court could not deal with that aspect of democracy. But with that, I will conclude. Thank you.
Thank you so much. That was fascinating and linked very nicely to our keynote address of last night when it comes to the limitations of the law, particularly now. Here we have our constitution affording certain possibilities, and then the institution of our courts basically not being able to live up to that. Thank you very much, Dani, for that. Let's move on to our next speaker, who's joining us from Slovakia, Dr. Luza Shirovia, and her affiliations have actually changed. I've just noticed in the chat here. She says she's a visiting research fellow at EduRoma and senior researcher at Bratislava Policy Institute, which is a think tank. And very welcome to you, Dr. Shirovia. You will be speaking on the situation required the adoption of those measures as they were adopted, securitization and quarantine of Roma settlements during the COVID-19 pandemic in Slovakia. Welcome.
Thank you. Hello to everyone, wherever you are at this moment. I tried this at dry run, sharing my screen, and I have presentation in Prezi. So let's see. Let's see if this will work. Tell me if you. Can you see it? Yeah.
Yes, we can see it. Yes, thanks.
Okay. So okay, I have to. Then I won't be able to see you. So we live in the age of COVID-19 pandemic, which has affected all areas of our lives, our personal lives, the different social, political, and economical dimensions of societies across the globe. Since the COVID-19 outbreak, this crisis has had unprecedented impact on public health, causing more than already 4.5 million of deaths, which is a really horrifying and really sad fact. And it was already early in the pandemic acknowledged that some individuals and groups are at higher risk of contracting and the outbreak of this virus. And among the most vulnerable ones are those marginalized and socially excluded, such as, for example, Roma communities are, among others. However, some states in Europe, instead of acknowledging this fact about the vulnerability of Roma communities, they have exposed them to the measures that the rest of the population did not face. For example, Bulgaria, Romania, Portugal, Greece, and Slovakia have put different kinds of lockdown on these communities. So there is an urgent need to understand COVID-19 pandemic, not only from the epidemiological point of view, but also as a social and political phenomenon that affects our rights and responsibilities, individuals and communities. Of course, on one side we have a state obligation to protect lives and public health, and this obligation can justify limitations of fundamental rights and freedoms, but not without the constraints. So all the measures have to be scrutinized in terms of their legality, necessity, and proportionality. So these were the reasons why I decided to do research on the quarantining Roma settlements during the first wave of COVID-19 pandemic in Slovakia. And yeah, into detail about that. Very briefly, I will just mention my theoretical methodological background of the study, then I will present you my findings, and I will finish my presentation with preliminary discussion. In my research, I am looking how were Roma communities put in quarantine in the first wave of COVID-19 pandemic in Slovakia. As I said, that happened last year in April and May. Then I'm looking why, who made this decision, under what kind of conditions, and of course I am analyzing this measure from the point of its legality, necessity, proportionality, and temporariness. So we are in the middle of pandemic, and I would rather say at the end, but we are only at the beginning of the understanding how COVID-19 impacts minorities. But there is already literature suggesting that racial and ethnic minorities are at high risk of catching this virus and the fatal outcomes of it. And also research of the European Union Agency for Fundamental Rights and European Commission report that the COVID-19 has disproportionate effect on Roma communities, mainly in areas of health, of course, housing, employment, education. And also there have been reported documented examples of so-called ethnicization of this virus when the states, namely those which I mentioned at the beginning of my presentation, ethnicized this pandemic in order to, and where they have labeled Roma communities as a security threat, as a vectors spreading the disease, as a burden to societies, and they expose them to do very strict measures. Also, many states have adopted securitized responses towards these communities. For example, human rights experts from United Nations have criticized overly securitized approach adopted by Bulgarian government when racially policing Roma communities if they stick to the COVID-19 restrictions. So I'm analyzing this topic from the perspective of political science. I deployed new institutionalism as approach, and I use securitization as analytical framework. This is a qualitative study. A qualitative method includes a case study, elite interviews, and qualitative content analysis. The data collection was done from desk and by field research during the toughest COVID-19 measures in Slovakia. When I speak about the Roma, I use it in a way that was defined by this term by Council of Europe. We can speak about all these issues if you would like in Q&A. I would like to proceed now with presenting what has happened here. Here I just put it, you can see respondent. I will just say this, that I try to speak with the actors who were in any relevant way involved in decision-making process, adaptation and implementation of this measure that quarantine Roma communities, and also with the people who evaluate it. So excuse me, I spoke with 25 key actors. Here I just put it, interview, meta table. Also, we can Q&A if you are interested to see what kind of categories of respondents were there. So, as I was saying, I use securitization as analytical framework. So I started my paper with saying how the issue of Roma communities became politicized first, then how it was securitized, who were main securitizing actors. I identify Deepen Prime Minister and his advisor as the main securitizing actors. They were making securitization moves in order to legitimize the quarantine and so on. Okay, but I have okay used a few minutes. I have still a lot of minutes left to speak of what has happened. So I cannot tell you how many Roma persons or person who identify as Roma live in Slovakia, because I don't think methodologically this is possible. But Roma population is at high risk in Slovakia of poverty, social exclusion, and discrimination. Institutions differentiate between Roma as national minority community as and also as marginalized Roma communities. Marginalized Roma communities are socially excluded communities, which are designed as a residential communities, spatially segregated and with the intergenerational poverty presence. So it took only a bit more than 1 month from the first case detected in Slovakia to the total closure of entire 6 Roma settlements by tape, guarded by army and police in Slovakia. Very important note is here that after the COVID-19 crisis started, there was a new government appointed in the office. And of course, key actors dealing with Roma communities, such as Deepen Plenipotentiary for Roma Communities, Healthy Regions. It is the subsidized organization of Ministry of Health, which does health prevention practice in MRCs, but also NGOs that work with Romas, Public Defender of Rights. They were all making appeals to government to tackle this issue that the Roma communities are most vulnerable due to conditions they live in. Deepen Prime Minister called the European Parliament member to come back and to take a place in a so-called Permanent Crisis Committee, which legally its legal grounding is questionable. And he was in charge of mitigating COVID-19 in MRCs. Very soon after, government brought this resolution, a plan who should do what and when and how in MRC to contain the virus and spread it and prevent it spreading. And also, the key actors were asking government to start testing the returnees. Many Romas were coming from abroad to the MRCs. So the government deployed an army and carried out testing in these communities. And only after a few days the testing started, boom, there was a decision made to close entirely Roma communities. Here is the map, but actually 3 communities were closed here, 2 here, I'm missing one marker in Jehra, and 1 here. It's in eastern of Slovakia. And 1 Roma community was closed before, but I'm not analyzing this. I will explain a question if you will have a question why that has happened. So here you can see some pictures, how that looked like, how they were taped and guarded. So who made this decision? It was the regional hygienist. She argued her decision based on the public health protection ground, of course mentioning epidemiological situation, and also that it was in line with the conclusions from this Central Crisis Committee. This is another committee which has a legal basis for his function, not as a permanent crisis committee mentioned before. But here in the first row from the right, you can see the then Prime Minister Igor Matovic, where after this meeting he went to the press. It was a meeting in one town when Roma settlements were closed, and he said he didn't want to say how many people were positively tested, but what he was saying, this is not an unfriendly act, this is an act of protecting them. The next day he goes on Facebook comparing Roma settlements to the bombs that are ticking. And and also the chief hygienist comes forward the next days, and he says, quote, "Initially, we considered quarantining people who had come from coronavirus. After considering local conditions and customs, they decided to close them." So he never specified what kind of conditions were these. Okay, so in my research, I hope that you can see, I will make this bigger. I was able to get the data about the results from this testing that the army carried out, as I was mentioning. And here you can see 3 cities where Roma communities were tested. And here you have the number of the positive case. And they repeated all those tests for till the end of May, and no one was tested positive afterwards. So altogether, tested cases. But what has happened, that they have actually closed 6 entire Roma settlements, and around 6,000 people were affected with this decision. Here you can see governmental resolution mentioned before that was adopted. There was specifically, it was stated there that they should close entire settlement only when more than 10% of whole population will be tested positively, which didn't happen in this case. So let me, I have to jump back in. 15 seconds. Okay, let me quickly say something about this measure from the point of legality, necessity, proportionality, and temporariness. And I will, Professor Christie, if you allow me, I will combine this with the conclusion. So I would need 2 minutes more. So
That's fine, Luza.
Thank you very much. So the quarantine, you can say, is a standard measure for protection of public lives and health, of course, but we have to be aware that it can limit our human rights and freedoms, and that's why it can be adopted only in a manner and for the reasons prescribed by the law. This has some. This is similar to what was Professor Brent speaking about. Those decisions has to be done in a constitutional legal way. So, and this particular measure lacked legal basis because the regional office who issued it didn't have so-called legal competence to do that, because it was state of emergency, and this state of emergency only governments and ministers can adopt measures to tackle the crisis. The issue of necessity. 6,000 people were closed, living in difficult conditions. Was this measure, closing them together, not isolating positively tested from the rest of the population, living in the conditions with limited no access to water, sanitation, and disinfection means? Was this really necessary for the purpose of protecting public health? In my paper, which I cannot go through all here, I argue not. Also, was this proportionate to the end? We don't know what kind of other possible solutions were at the table. This is also the issue what was open during all this conference about the questions of openness, transparency, democratic principles, participation. All these decisions were done behind the closed doors. so the constitutional also, when temporariness decision was made, and there was no ending date in that issue. It lasted for weeks, 3, 4, 5, 6 weeks. Those people didn't know when it will end based on what has to change that it finished. So a lot of concerns. This measure raised a lot of concerns about legal grounding, about ongoing violation of fundamental rights and freedoms of these people. There are broader questions relating to the democracy of the democratic process, as I was mentioning, also the issues of equality, non-discrimination, and now the last thing I conclude with this. I don't have now time to go through what the respondents were saying, but let's just conclude with this measure. It was disproportionate. The Roma communities were turned from vulnerable group very quickly into security threat. Securitization was used as a justification for this measure. The measure treated Roma communities collectively, not as individual citizens with their own rights and freedoms. A lot of fundamental rights and freedoms were violated. This also what the previous Professor Levin and Ngubane were mentioning in their presentation. It is the same, that the labor tenants were not treated as citizens. It happened also here. They were discriminated against, and my probable explanation is presence of the fear. Really, those key actors had genuine fear. What will happen in MRCs if the COVID-19 comes there, but they have also fear that the Roma vectors will infect a wide majority. And also the other explanation is presence of the systematic racism and institutionalized securitization in Slovakia, that actors, even when they wanted to help these communities, did not avoid. Thank you so much. I'm sorry that I overtook my time. I'm looking for your comments and questions.
Thank you so much to Luza for that, and for our other presenters. I think we're finding some interesting strands running through these papers around failures by the state, around abuses by the state, around our courts here in South Africa being able to step up to deepen democracy or not. I'm just noticing, we are in these exceptional circumstances, and we are very much aware that states have been able, through emergency measures, to in a sense, claim powers for themselves that wouldn't otherwise be possible at other times. And of course, what Luza has shared with us now is a very good example of the kind of abuse that can happen in relation to marginalized communities. We know there's a very long history, of course, with pandemics and epidemics being abused by authorities to racialize, exclude, and isolate and harass certain communities. So here we have a very good example of that. I'm also just thinking around the whole question of Richard and Corby's paper around the special master that was created, particularly in response to state failure, yet again, this time in relation to labor tenants, labor tenant claims not being properly solicited, and that actually then leading to the Constitutional Court's decision to create, and I think this is quite, they can tell us whether this is unprecedented. It's quite an interesting thing that the Constitutional Court actually created this special master through a decision, as I understand. So, and then Professor Brand's paper just on how our courts get offered an opportunity to expand thinking around the law and the role of the court, and to deepen our democracy, and actually failing, when they're presented with this opportunity. So let's move over, and I want to ask our audience to please give us some more questions and comments. We have two sort of commentary type questions here. There's one from Zander Yeller. He's talking about the paper by Richard and Colby, saying this is an interesting argument. An excellent parallel exists on another 10-year security front. Communities hosting mines might be successful in retaining land for homesteads and dense parts of villages, while they lose grazing land and farming fields to strip or open cast mines, and therefore livelihoods. So you may want to comment on that, Richard and Colby. I also just want to throw in a question there around, because you're talking about decentralized despotism, including the white farms. Is it because the Labour tenants on the white farms, when it comes to governance, because do they fall under traditional councils, or are you just using the citizen subject division to illustrate that Labour tenants are basically rendered subjects because they're on these white-owned farms? So if we could kick off with those two questions to Richard and Colby. Well, the one is a comment rather from Zander.
Okay, I can respond as well as to the other issue you raised. Robbie might want to comment on decentralized despotism, but I can also do that. But I'd like him to try that one. But anyway, let's say, because you introduced the thing, you asked, is the special master unique? And there's Dani, he would confirm it is unique. If you look at the Cameron judgment, which implemented or reinforced the decision of the Land Claims Court, the nub of it, the central element was that the special master is an independent agent of the court and is an extension of the court's supervisory powers over the administration, over the department. So it's quite a unique kind of arrangement. And I'm not a legal person, but I've been in the commanding heights of public administration for many, many years. So interpretation and application of the law, obviously, I'm familiar with. But as an administrator, one of the finer points of that decision is the supervisory powers, because that is where there's contestation. Now, supervision involves direction, which involves management, and that's where there's a lot of resistance, because clearly to change the way in which settlements are reached. And let me dive into the comment from Zander, because we are dealing with cases. After the session, I have to go to a farm in Mpumalanga where there is a situation like that. But I've already been in the Middelburg area to a number of farms where very, very powerful landowners with mineral rights, Anglo-American Exaro, are currently practicing open cast mines. Labour tenants have claims on that. The Constitutional Court precedent is in Maledu and others versus Itereleng Bakatla Mineral Resources Pty Limited, where informal land rights were upheld as being the local owners in terms of Section 42 of the Mineral, Petroleum and Resources Development Act. Now, and the way in which the department deals with this is they use Section 18 of the Act, which allows Labour tenants to waive their rights. And then the mine owners are free, in a sense, to equation and put them in little houses. But my view is that the land rights they have been trampled on because their claims were unresolved. And the actual extent of their land rights have never been explored and tested in a court of law. And the Labour Tenant Land Rights Act actually gives them more substantial rights than the land that they are going to be squeezed into. And that's been the problem with the exercise of the Act. People are squeezed onto rocks, onto cliffs, and then comes the department, enters into a settlement agreement, and we have this continual impoverishment and marginalization of people who have real land rights, which the Act provides the space for them to actually attain and acquire land holdings which are not the entire farm, but which would enable them to engage in agricultural petty commodity production. So that's what I would have to say about those two matters. But I would encourage Ngobi to talk about decentralized despotism. Thank you very much, Christy.
Should I come in there? Okay, thank you, Richard. So basically, the Office of the Special Master, if you think about it theoretically in terms of legal terms, what it is trying to do is to deepen democracy by dealing with the oppressive social relations that former labor tenants are subjected to on these farms, to actually make them realize the fruits of democracy, where their movements, for example, are not controlled, where they will be able to access state services, municipal services, as other citizens of this country. In many cases, throughout the country, people still live on farms, and they live under very oppressive conditions where their lives are controlled by landlords who do not see themselves accountable to the local state. So the Office of the Special Master will help to actually get rid of these oppressive social relations in court, so as to deepen democracy, to reach the people who have not yet realized, people who have to report their visitors on the land, people who are denied state services on the land because they are subjects of these land. I can leave it there. Thank you.
Thank you so much, Ngubane. I appreciate it, and to Richard. Moving over to Dani. So yeah, it's a very interesting court case that you're giving us as an example now of the limitations of our court, or the kind of, I don't know, frame that our courts still seem to be caught up in. I was wondering if you think what would have happened if this was elevated to the Constitutional Court? Do you, if De Beer decided to take it, had decided to take it further, do you think that the Constitutional Court would have come to a different or to a different realization, or would have been able to expand the frame beyond what the Supreme Court of Appeal was able to do? And I also wanted to talk a bit about, it's interesting what you were saying. We've got a bit of feedback. I'm saying it's interesting what you are saying around the fact that it seems like there was a bit of a fisticuffs between De Beer and the court. Tell us a bit more about that, the fact that the court felt scandalized by De Beer's interaction with the court. Tell us a bit more.
Yes, thank you, Christy. About the Constitutional Court, well, not to be flippant, given how long the Constitutional Court is taking to render judgment in very simple matters at the moment, I'm not sure what the Constitutional Court would have done with this, but no, I don't think, in fact, that it would have been different before the Constitutional Court, because the basis upon which the Supreme Court of Appeal rejected, by overturning the High Court's judgment, rejected Mr. De Beer's application, is a very fundamental rule of our civil procedure. And the problem is, as I see it, is that with a constitutional dispensation entering our law in South Africa, we've not, although we've made the shift to take account of a constitution with substantive constitutional rights in substantive terms, we've not yet made the shift in our courts in procedural terms. Our law of civil procedure has not been adapted to take account of these kinds of cases. if you read the Supreme Court of Appeal judgment, then you will see quite clearly that the judgments that are relied on to come to these conclusions are all constitutional court judgments. So I think there's a big problem to address that, and it's a kind of a systemic problem that we need to develop a separate, as there is a separate law of procedure for criminal matters, we need to develop a separate law of procedure for what really are non-civil matters. They're not civil matters. They are public matters, and there are examples across the world in other jurisdictions of how to create a law of procedure that allows for these kinds of claims that do not fit into the rubric of a dispute between two discrete parties in which they try to advance their interest, and have nothing to do with the public good, at least not directly, and have nothing to do with democracy. That's as to your first question. Thank you, Christy. Then the second, De Beer is the case was brought by De Beer himself, and then on behalf of an organization, ostensibly on behalf of an organization, the Liberty Fighters Network, but that really was just, it seems, De Beer's own little show. And he proved throughout the litigation to be a difficult customer, an idiosyncratic person. There was, what I didn't mention, a number of applications during the course of before the appeal was heard by the Supreme Court of Appeal, that he brought contempt applications against the minister, and so on. But the background to what happened in the Supreme Court of Appeal, and that led to that part of the Supreme Court of Appeal's judgment, was that in the run-up to the hearing in the Supreme Court of Appeal, the Supreme Court of Appeal issued directions that the appeal would be heard virtually, as all appeals have been for the last year and a half in the Supreme Court of Appeal and in most other courts across the country. Mr. De Beer objected very strenuously to that. He refused, in fact, to subject himself to a virtual hearing. So a correspondence ensued between the court and Mr. De Beer through the registrar of the court, and Mr. De Beer wrote several letters to the registrar that he sent only by email. There's a rule in the Supreme Court of Appeal that letters are only brought to the attention of the judges if they are sent by hard copy to the Supreme Court of Appeal. So the letters were never sent to the president of the court. De Beer pointed this out, and then the registrar wrote back saying that she apologizes, and this is the reason why she didn't give the letters to the judges. And then in response to that apology, De Beer wrote a letter in which he says, among other things, the following to the Supreme Court of Appeal. First, after careful consideration of your official response, the writer has decided to herewith inform you that the entire Supreme Court of Appeal may stick its fictitious apology to us in its arse. That is the first line. And then secondly, as the leader of the institution, he addresses this to Justice Maya, who is the president of the Supreme Court of Appeal. As the leader of the institution, you've allowed the COVID-19 flim-flam to take over the court's judicial function and for it to desecrate the institution to the point of pure codswallop, which it is today. Nothing but a mere extension of government's narrative, a court which has lost its independence and which has become incapable of protecting the Constitution of the Republic of South Africa, etc. So that's the gist of what the court was reacting to. This is the scandalization of the court that the court refers to. Of course, it has to be seen in the context of the attacks on the judiciary that are very real and not slightly amusing as this one is. In addition, he also challenged on the basis of this virtual hearing, he brought an application that the judges that had been assigned to the case in the Supreme Court of Appeal should recuse themselves from the matter. His argument was that by going for a virtual hearing, in essence, they had shown a preference for the COVID regulations, so that they pre-decided the case against him, and the court reacted very badly that application, also saying that it had no grounds and that it was also an instance of scandalization of the court. My point is not that the court is not correct in reacting in the way that it did, particularly given the current context. I think it's necessary for the court to react very strongly against these kinds of attacks on the independence, particularly of the judiciary. My point is more that a court is not really a place that can take account of democracy in this kind of a rude, rambunctious, whatever else you want to call it, form. Thank you.
Great, thanks so much, Dani. Luza, we have a question for you from Professor Andre Keet. He says, many thanks for a great presentation on quarantining Roma settlements. 2 questions. One, in our context, research generally pathologizes township and Black communities, which is also observable in a COVID-19 pandemic modeling in South Africa, and the responses from the army, police, and other state actors. Is pathologizing Roma communities within research also predominant in institutions in Slovakia, which then influences state action? So he's basically asking that is this pathologization of Roma people also happening with research in Slovakia, and if so, is that then influencing how the state responds to Roma people? And then he also says, why after so many decades can't Europe respond to the plight of the Roma from a human rights perspective? What is the crux of this matter? I think it's well known, also even to our South African audience, that the Roma people have been historically marginalized, and of course was one of the communities particularly targeted by the Nazis in the Second World War, with thousands of people being killed simply for being Roma, and the Sinti as well. So, Luza, how do you respond to that? Just switch on your mic, please.
Yeah, thank you for the comments and questions from Professor Keet. They could not have been easier. They're quite difficult, but maybe I will start with the second one. I think that Europe it is approaching to the Roma communities from a human rights perspective. If you notice at the beginning, I counted only a few states. So in EU, not all states took these kind of actions towards Roma communities. And sadly, this was in the first wave, and in the second wave, Slovakia was only country who continued to close in this kind of manner, maybe a bit slightly different, but let's say in this kind of manner. So I think that change is happening, but very slowly. And that maybe has to do with the first question, what Professor is asking. And to be honest, I don't know if I can answer his question based on the data that I gathered. What I have learned in my research, I didn't have time to say, speaking with all those key actors that were adopting these measures. It is difficult to say if they even use some research to build their policies upon, or it were only their opinions, not to say stereotypes behind that. But I can say that the ones who really issued these measures, they don't think they did something wrong. Yeah, and I think in this way it is important what was brought up in this conference, and I liked a lot this the issue of democratic oversight of decision made, and not only citizens but also scientists. We should put our wrap up our sleeves and do something about that, and actually analyze what has happened, why, and also try to maybe answer the question who is responsible, the question of accountability. I didn't have time to come to in my presentation. So I'm really sorry that I'm failing to answer these very important questions of Professor, but it is very complicated. But I am optimistic in the second one. In the first one, that's the question of interplay of science and politicians. In Slovakia, in general, I would argue that politicians do not make all decisions on evidence and scientific-based approach. So, but if I could answer a bit differently, like this, I didn't have time, but I will show you the lesson learned from this in Slovakia. I didn't have time. So this is one respondent politician who was defending the measure, and he says, close or not to close, no one had a plan for it, no one had a motive, no one was in this situation, what to do next. I think that in this situation, having learned this, I believe that the other measures would have been probably taken. Okay, so this interview was done after the first wave, and we have actually learned after closing the Roma settlements. The blue markers point to the closure of Roma settlements in the first wave, and the red markers point to the closure of Roma in the second wave. So let me come back. We didn't learn a lot, and I don't think that I would argue that research does not pathologize Roma communities, but actually the actors see them not as they see them as objects of their policies. They don't see them as actors in their own rights, with rights and freedoms. And you know, so I don't know if I, in maybe little way, was able to answer these questions.
Yeah, as you were saying earlier, that's in a sense something that we're seeing. We're seeing a resonance here between this community that you are describing and how they're objectified by the state and the labor tenants that Ngubane and Richard are researching, and that Richard is now tasked with trying to protect their rights and trying to empower them to gain access to their land and hold on to their land. So I'm just noticing that we have a question from Trevor Ngubane, who is saying, what must happen once the labor tenants get their land back, legally, economically, and ideologically? And this actually goes to in the conference as well about the kind of society that we're trying to create. When we're talking about deepening democracy, when we're talking about inclusion, what does that actually look like? I'm also just struck from what Ngubane and Richard are describing, that what's happening with the labor tenants seem to be very similar to people under traditional councils in relation to mineral rights. We're seeing a similar kind of scenario playing itself out. So we have basically our political and economic elites conspiring to continue the dispossession of people who've been historically dispossessed, but now under new guises, and by finding ways around the protective legislation that we've been trying to put into place, well, for labor tenants. But of course, we know that people under traditional councils don't have the same rights as you and I. So, and that's why those laws have been challenged. So if you, Richard and Ngubane, do you want to quickly respond to that?
Thanks. I'll lead in, and then Ngubane can sweep up. I think legally, there's certainly labor tenants would be entitled to full freehold title land rights, but there are limitations with that. So, for example, Tembega Ngubane has pointed to the fact that even freehold titles do not guarantee access to bank loans. I think there's a lot of discussion now around the concept of custodianship. I think it would be important to explore that, because it might actually ultimately be more protective of their rights because there are social forces out there that could lead to freehold title being lost in exchange for a quick fix as opposed to sustainable. But those are the options. And I think empowering people to make their choices is critical to the way in which we're working through the Office of the Special Master. So we believe in participatory development evaluation in order to reach decisions within the law which will empower labor tenants to take the best choices under the particular circumstances which they find themselves in. Economically, we do need a recognition of the fact that these are agents with capabilities. Yesterday, I was in a farm in Kaap Maiden. The most appalling conditions I've seen. It's a very traumatic job doing this work. But we have 108 legitimate bona fide labor tenant applicants who are being squeezed into 14 hectares of land. There's a whole swath of that farm that has been given to other land reform beneficiaries many years back, and they are conducting a successful contract business operation with the neighboring sugar mill on land which they have historical rights to. Now, interestingly enough, one of the respondents I interviewed, a woman by the name of Lucy Hlachwayo, when we asked what compensation would you expect for the trauma you've been through psychologically and the assets you've been stripped of historically. And she said, well, I'm not interested in millions of rand. I'm interested in security of tenure so that ourselves and our extended family would be able to reproduce ourselves through working off the land. So that people don't production on the land. And that's what we've spoken about in our input. Ideologically, we need a transformation which will give people pride, a sense of belonging that Stayeni talks about, and dignity. And those are the ideological components of the transformation of subjects into citizens. Thanks. Moby?
Thank you so much, Richard. And I would add that on the land that has already been redistributed to former labor tenant households, we are seeing progressive dynamics there of democracy. We are seeing, for example, offspring, so to speak, girl children who are in their youth, young women getting land through their families, and we are seeing increasing livestock herds on former labor tenant farms. So the issue of what people will do with the land, if you look at the land that has been redistributed, the answers are there. People are using the land for homestead expansion. They are using the land to restore their dignity. They are also using the land for farm production. So those are the elements of our democracy that we are beginning to see through land reform. And hopefully with this work of the Office of the Special Master, these elements will be elevated even further. Thank you.
Thanks so much, Ngubane, Richard. Dani, Luza, if you could just wrap up each of you, I'll just give you a last minute to just share with us some final thoughts from your side. Dani, let's start with you.
Yes, thank you, Chrissy. I'm actually going to just make a comment on Richard's and Ngubane's paper. Richard, I was very gratified to hear your reference to the Maledu case, because I was co-counsel in that case. So, but not only for that reason, because it's an example of a case where it was not about housing and residence. It was only about the agricultural use of land in the first place. In the second place, it's a case that very clearly illustrates your point about freehold, and freehold not necessarily being the solution here as a form of security of tenure, because freehold, of course, does not trump a mining right. What does trump and what did trump a mining right in the Maledu case are informal rights, as you said, in terms of the Interim Protection of Informal Land Rights Act, which are very tenuous rights. In one sense, they are also tenuous because the Interim Protection of Informal Land Rights Act, the IPORA Act, is a very tenuous piece of legislation. It is really only interim legislation. It has to be renewed every few years in order for it to stay in operation, and it is frequently under attack from mining companies and others, traditional leaders, to try to get rid of it. But as often happens, sort of counterintuitively, these very tenuous tenure rights in the IPORA Act have turned out to be the best protection against intrusion by mining companies and also other entities such as traditional authorities who try to interfere with people's land rights. Thank you.
Thank you so much, Dani. Last minute to you, Luza.
Thank you, Professor. Well, thanks for having me here. It was really wonderful conference and really intellectually engaging. And when it comes to my case, I would just want to say that this what has happened to Roma communities in Slovakia and what is continued to happen on a very large scale, it has broader implications for democracy and societies we live in. And I would like to see that this would change, that the Roma communities would not be seen always as the usual suspects, that they would not be treated as collectively in a discriminative manner, and that they will also start their own struggle for what Ngubane said. I really like that struggle of the tenants for land is a struggle for justice, and I think also that this corona crisis maybe can help us to think more about most marginalized and socially excluded, and how to return them agency and give them voices to speak about for themselves, and also to be included into the process of when some decisions are made about their lives. We are talking here about the lives. So thank you so much once again for everybody.
Thank you so much. That was really excellent. We very, very much enjoyed having you and just listening to this very, very rich discussion. I'm sure my audience will agree. I also should tell people that all of these recordings will be shared on YouTube in the next 2 weeks. So if you want to revisit these really wonderful discussions and engage, as Luza has been saying, intellectually again, and please do so. We will be sharing that with you on the email where exactly you can find them. Thank you, Dani, Richard, Corby, Luza. This is really excellent. Thanks a lot. And we are going to go into our parallel sessions now at 11 o'clock, which I want to invite people to join us. Again, it will be like yesterday when you had to click on a link. I'm sure my colleagues will share with us the link in the chat very soon. We've got a breakout room, and you can move from the main auditorium to the breakout room if you'd like to attend the session in the breakout room. So in the main auditorium where we are now, we've got nationalism and black conservatism. And in the breakout room, we'll have neoliberalism and the left. So if you want to join us at 11 o'clock for these sessions, in the meantime, you can grab a cup of something, stretch your legs, and then we'll see you back at 11 o'clock.